తెలుగు ఎన్ఆర్ఐ రేడియో ఇది ప్రవాసాంధ్రుల గుండె చప్పుడు.
హలో మై డియర్ వండర్ఫుల్ లిసనర్స్, గుడ్ మార్నింగ్, గుడ్ ఆఫ్టర్నూన్, గుడ్ ఈవినింగ్ అందరికి. మీరు వింటున్నారు తెలుగు ఎన్ఆర్ఐ రేడియో, ఇది ప్రవాసాంధ్రుల గుండె చప్పుడు. అండ్ నేను మీ హ్యాపీ అవర్ షో ఆర్జే నమ్మి. ఫస్ట్ ఆఫ్ ఆల్ హ్యాపీ ఫ్రైడే అందరికి. ఐ హోప్ మరి యువర్ డే ఇస్ గోయింగ్ గ్రేట్ సో ఫార్. మరి ఇవాళ మన హ్యాపీ అవర్ షోలో ఒక సూపర్ స్పెషల్ ఇంటర్వ్యూ అవబోతుంది అనమాట. సో ఐఎమ్ షూర్ అందరికీ కూడా చాలా యూస్ఫుల్ ఇన్ఫర్మేషన్ ఇవాళ ఈ ఇంటర్వ్యూ ద్వారా మన స్పెషల్ గెస్ట్ ఇవ్వబోతున్నారని. ఎందుకంటే మరి H1B క్యాప్ కి సంబంధించినటువంటి, అట్లానే H4 EAD రిమూవల్ కి సంబంధించినటువంటి అప్డేట్స్ రీసెంట్ గా న్యూస్ లో వచ్చాయి. అలానే రీసెంట్ గా జరిగిన ఫార్మింగ్టన్ యూనివర్సిటీ ఎపిసోడ్ కి సంబంధించిన మరి స్టూడెంట్స్ చాలా మంది డీటెయిన్ అయ్యారు కదా. సో వారి కరెంట్ అప్డేట్స్ ఇవ్వడానికి కూడా ఇవాళ మనతో పాటు ఒక స్పెషల్ గెస్ట్ ఉన్నారనమాట. సో మై డియర్ లిసనర్స్, ఎటువంటి డిలే చేయకుండా నేను వారిని ఇంట్రడ్యూస్ చేసేస్తాను. ఎవరంటే మరి టుడే వీ హ్యావ్ విత్ us the super charming, super supportive attorney Lucas Garriston from Burgos and Garriston Law Firm. So today, like I said, he is here to give us updates on the recent changes that have been proposed for H1B cap subject petitions and H4 EAD removal program, and also to give us an update on the legal proceedings that have taken place so far for the detained students from the Farmington University. So without any further delay, let us welcome him on our show. Hi Lucas, a hearty welcome to you to Telugu NRI Radio.
Good afternoon. Thank you for having me. It's a pleasure to be a part of the program.
Same here, Lucas. So I think this is your third interview this year with us, and we couldn't be more happier to host you on our show.
Well, thank you. Thank you. I love being a part of these shows.
Super. So yeah, and we really appreciate all your continued efforts so far in trying to help the detained students, and not just them. You've been very proactively doing these shows and trying to help out all the other students also by clarifying their doubts and guiding them. We really appreciate that.
Thank you.
Yeah, so you know the drill, Lucas. So first I'm going to quickly announce our dial-up numbers to the listeners so they can give us a call and speak with you. And right after that, we'll begin with the interview and take calls as and when we get them.
Perfect.
Okay, so my dear listeners, క్విక్ అనౌన్స్మెంట్. మరి అందరికి ఇందాక నేను చెప్పినట్లే H1B క్యాప్ కి సంబంధించిన, అట్లానే H4 EAD రిలేటెడ్ రిమూవల్ కి సంబంధించిన క్వశ్చన్స్ ఏమైనా ఉన్నట్లయితే, అండ్ ఫార్మింగ్టన్ ఇష్యూ అప్డేట్స్ కూడా మీరు తెలుసుకోవాలనుకుంటే, ఇవే కాకుండా ఏదైనా మీకు జనరల్ ఇమిగ్రేషన్ రిలేటెడ్ క్వైరీస్ కనుక ఉన్నట్లయితే, దిస్ ఇస్ యువర్ బెస్ట్ ఆపర్చునిటీ టు గెట్ దెమ్ క్లారిఫైడ్. సో మరి తప్పకుండా లూకస్ గారికి కాల్ చేసేసి మీరు ఆ క్వశ్చన్స్ కి ఆన్సర్స్ ఏంటో మరి అడిగేసేయండి. మరి మీరు కాల్ చేయవలసిన నంబర్స్ ఏంటంటే, ఇండియా లిసనర్స్ 9705222005 కు కాల్ చేయండి. యుఎస్ఏ నుంచి చేస్తున్నట్లయితే 9197012005 కు కాల్ చేయండి. యూకే నుంచి చేస్తున్నట్లయితే 1158882005 కు కాల్ చేయండి. మరి స్కైప్ నుంచి కనుక కాల్ చేస్తున్నట్లయితే తెలుగు ఎన్ఆర్ఐ రేడియో అనే ఐడిని సర్చ్ చేసి కాల్ చేయడమే. అండ్ ఇన్ కేస్ మీరు ఏదైనా మీకు ఇమిగ్రేషన్ రిలేటెడ్ క్వశ్చన్ ఉండి మీరు కాల్ చేయలేకపోతే, మీరు తెలుగు ఎన్ఆర్ఐ రేడియో @gmail.com కి మీ ఈమెయిల్ ని పంపించవచ్చు అనమాట. తప్పకుండా నేను ఆ క్వశ్చన్ చూసి చదివి లూకస్ గారిని అడుగుతాను. అండ్ వన్ సింప్లెస్ట్ వే ఏంటంటే, మీరు తెలుగు ఎన్ఆర్ఐ రేడియో యాప్ ని కనుక డౌన్లోడ్ చేసుకున్నట్లయితే మీరు అక్కడే మరి షో వినొచ్చు, అండ్ అక్కడి నుంచి జస్ట్ క్లిక్ అవే కాల్ కూడా చేయొచ్చు అనమాట. ఓకే, సో మరి అనౌన్స్మెంట్ అయిపోయింది కాబట్టి ఇక మరి కాల్స్ కూడా తీసుకోవడం స్టార్ట్ చేస్తాము. సో ఎటువంటి క్వశ్చన్స్ ఉన్నా కాల్ చేసేసేయండి. ఆల్ రైట్, సో ఐ మేడ్ మై వెరీ క్విక్ అనౌన్స్మెంట్, లూకస్. సో యా, లెట్స్ బిగిన్ విత్ ది ఇంటర్వ్యూ నౌ.
Sure.
Okay, right. So, okay. So the calls have, I mean, you have a lot of fans, Lucas. The calls have already started pouring in. So we'll take calls then first.
Sure. Not a problem.
Yeah. Hi, welcome to Telugu NRI Radio. Hi, may I know who's calling?
Here, Venkat here.
Yeah, please go ahead, Venkat, and ask your question.
Sure. Hello, sir.
Hi, Venkat. How are you?
Doing great. Thanks for asking, sir. Very good evening.
Good. How can we help you?
Yeah. So actually, I came to USA in 2017 on a consultancy name as like A. So in the beginning of the year in 2018, I changed I transferred my employer from A to B. And here at B, I got an RFE where my employer is not ready to answer that RFE. I don't know what is the problem with him. So then what I did, I changed from when it is in RFE only, before the response time, I changed my employer from B to C.
Okay.
Did you getting, sir?
Yes.
Okay. So when I changed my employer from B to C, at the same time I changed from B to D also. I put it to H1B transfer. 2 employees changes from B to C, B to D. Just 2 days gap.
Okay. And when you
Right.
did those 2 changes, did you use the same project and location and SOC code?
When I'm working with employer B, my client is in Wisconsin, so I'm working at Wisconsin. So from there, when my employer said like I can't give a response to RFE, so that he said you can change a project or you can change the employer. So what I did, when I'm working with employer B, the Wisconsin client is not ready to provide the documents by vendor and by client also. So what I did, I changed my project who provided the client letter and all the document. So luckily, I from when I'm transferring B to C, I got the all documents. At the same time, I transferred from the B to D, I got all the documents. But B to C, when I'm changing from my employer B to C, C is a remote project. I'm not okay with the remote project. So since I changed to my project where it is located in North Carolina, so I working at the client location right now. That is the employer D. So this employer didn't get any RFE, any response. But after all the time, just 2 days back, the employer C who petitioned for the remote project, right? So for that it is approved. Now my another H1B is approved. So what can I change my? Can I drop my employer D and I move to the employer C, or shall I wait for the D response also?
Well, that's clearly up to you as far as what you would want to do. As far as remote work, typically you're required to work at the work location where the work's going to be conducted. So depending on how that's arranged in Wisconsin, or is it North Carolina that's the remote?
The North Carolina is a client location. There is no remote project.
So when you say you have a remote project in Wisconsin, where were you actually going to be working from?
Like when I'm working in Wisconsin, I'm with the employer B. So the employer B got an RFE. So
okay, so who's the one where you're working remote? Is that C?
Yeah, I'm not started working with C.
Right, and that was the one you said was remote.
That is a remote project. That is got a remote project, but I never worked with the C or remote project.
I understand. So where was your work location scheduled for?
It's
C?
Chicago.
Right, but was it in whose office was it in?
It's my employer's office only.
Okay. So that's your work location would be is the office. So it's not like what we would call remote work, because your employer would be conducting the work and managing you and things like this. It's really it's up to you if you wanted to go to B or C or D. It's really your choice. You do need to be maintaining status while you're in this position. Even if your petitions are pending, you still need to be on payroll and maintaining status, right?
Yeah.
So as long as you're doing...
Sorry. So from
Go ahead.
the last, for more than 4 months, my pay slip is from employer D. There is no pay slip is started with the employer C. So can I change it immediately from employer D to C and start my paycheck, or I want to wait for the D response also from USCIS. So
You
what
can
is
do
a
that.
good idea?
You can do that if you wanted to. If you filed the petition for D before December 21st, 2018, you could go ahead and upgrade that to premium processing if you want. The main thing is if is that your I-94 is current, and while your transfer is pending, you can keep working until a decision's made on your case. Now, there's many in the scope of the time we have available. I mean, it's really you have the luxury of kind of choosing what works best for you at this point.
Yeah. So my employer, he never claim that he is my employer and I have to come to his location and starting work, right? There isn't something, not anything force or something like a legal issues.
I mean, whenever you report to officially join the employers, when they would bring you on payroll, when they start the employment agreement, things like that. So to be honest with you, without seeing everything in detail, it'd be hard for me to give you a definite answer. But there's nothing at this moment that would require you. I don't know what your joining date would be, what your validity period is on your approved petition. So all these are factors that would go into making that decision or determination of what you should do.
Got it.
Okay.
Got it. Yeah. My I-94 is valid till September. So even I started my premium process, maybe on Monday, my employer going to give a notice. So
very good. Yeah.
probably.
So, well, good luck to you. It sounds like you have a lot of good karma going your way. So hopefully you get also approval for job D, and then you can figure out the best scenario for you.
Thanks a lot.
You're most welcome. Good luck to you.
Yeah. Have a great day.
You too. Thank you.
Thank you.
All right. Thank you, Venkat. Okay, so we have another caller, Lucas, so we'll take that call as well. Hello.
Hi, Chandan here.
Yeah, Chandan, please go ahead. Yeah.
Yeah, my wife is currently on H4 EAD and she's working. So yesterday, through this restaurant, I saw news regarding H4 EAD removal. So I just wanted to check, is there any timeline when it may be revoked or?
Very good question. Very good question. So that was part of our one of our talking points today. Basically, what's happened is we've known for over a year there's certain litigation that's pending through the courts for USCIS to withdraw H4 EAD. USCIS has until March 1st or so to respond to a motion for that proceeding. Now, they also have the option to change the availability of H4 EAD through a rulemaking process, and that's what they've gone ahead and also done. I guess is their plan B to kind of keep all doors open for them. From how it impacts us today, there's no change. It's the same as we've been under this pending change for more than a year now. And I always tell people, until something changes or something's implemented, it's not, there's a lot of different things that could happen along the way. So what we know right now is the rulemaking process is typically open for 60 days. We do know that USCIS has requested that they want to, since it's an economically significant change, that they want to request it going from 60 days to 30 days on the comment period. So, I mean, they're trying to speed that up, but here in the next month to 2 months, I mean, there won't be really any change until one of these two processes is concluded. If your wife has H4 EAD, and let's say her EAD expires in February 2020, typically she should be able to maintain her EAD until the EAD itself expires, and it would just really impact her, should only impact her as far as renewals and things like that.
Oh, okay. So my wife's H4 EAD is valid till like 2021. So you're saying it will impact only for the renewals, but the existing ones will still hold good?
Unless there's something that has been proposed that, that would change things significantly from what I've seen and from what I've read, you would still be able to maintain and have your EAD until the EAD expires. But again, the final rule hasn't come out yet. So there's a lot of, it just depends on what the final rule says. We can all speculate and guess what could or could not happen, but the process is moving forward. And of course, this type of benefit is here. Now, I want everyone to understand that the H4 EAD was created out of necessity, because if you're from India and your employer, you're here on H1B and your employer files an I-140 for you, the typical process for most all other countries is, well, within 2 or 3 years, you don't have H1B anymore, right? You're transitioning to having your GC. And then from the GC, you would become citizen or whatever else would happen, right? Well, the country limits are so behind on the EB2, EB3 categories are so far backlogged with from India that right now, if you were to have a priority date of, let's say, January 1st, 2019, you're looking at like 50 to 60 years before your date becomes current. So what are you supposed to do? Are you supposed to have a one income household? Like, is your spouse supposed to just patiently be there? I mean, people have careers, people have lives, you know what I mean? So it's not necessarily, the program was created to help relieve economic pressure off of single family earners, So, here in America, most families, both husband and wife work, it's an equal society. We want both husband and wife to progress their careers equally. So that's why I'm bringing up these points, that there's still, even if the government comes out and says we're going to revoke H4 EAD, there's still probably substantial ground of where the lawsuits could be filed, similar to what's happened with what they call the Dreamers, the DACA recipients, to have federal court litigation to stop the government from these changes taking effect. So there's a lot of not just action the government has, but there's a lot of reaction that H4 EAD holders might have if the government just removes this. Or it's also similar to some TPS issues that have come up, right? So I wouldn't say that the sun is falling right now. Does that make sense?
Yes. Okay. And just one more question related to this. So in case if my wife wants to change status from H4 EAD to H1, so earlier she was working in H1, and in between she changed to H4. So is there an option to change back to H1?
Yes, and that's a very good point. I've a lot of my clients that I speak with, we've utilized the flexibility of H1B, H4 EAD amongst husband and wife. There's a lot of strong career women, is same as career men, within the software development community and things like this. And what we've always said is, like, what happens if you lose your job or something happens? Here recently, there's been a lot of people affected with Cognizant. A lot of people have been denied. And Cognizant is such a big company, they just say, hey, here's your plane ticket home. So a lot of other people we've been able to help because maybe the wife was on H4 EAD and she already was cap exempt from a previous H1 petition, and we can quickly kind of get that process moving to switch back over to H1, and that helps buy time and keep the family here, because most people who are in this situation, you've probably been here for a number of years, and you might even have kids here and a house, so it's a lot to have like such drastic change affect you.
Right.
Yeah. Thank you,
Yeah,
Lucas. And
you're most welcome. And take advantage of premium processing if she does consider changing status whenever it's premiums current for all cases. I would consider maybe doing a change of status back to H1B whenever she feels that's appropriate. Okay.
Yeah. Thanks a lot. And thank you, Nammy.
Yeah. Thank you,
Most welcome.
Chandran, for calling. All right, so we have another caller, Lucas, but just before we speak with him, I just have a very quick question here. So, do we have a timeline on this as to when, it is finally going to come into effect once this 30-day comment period ends?
Well, it's similar to, so since it's administrative law, regulations and everything, they have a comment period that they should be following. After the comment period ends, then they can go ahead and go and put the rules to the OMB and have the rules take effect based upon whatever date is appropriate from the new proposed rule. So it just depends on what that's going to be. Well, like I said, there's a lot of speculation, but I think this is just really good evidence to show that USCIS is just working on their Plan B. Plan A, they still have pending. This is just their Plan B.
Okay. All right. Okay, then I think we're good to take the next caller. Hello. Hi, welcome to Telugu NRI Radio. May I know who's calling? Hello. Okay, so we can't hear you. Can you please try calling us again? Thank you. Yeah, so Lucas, so while we are at it about the H4 EAD holders situation, so I just have one more question. I mean, you have explained the case for the existing H4 EAD holders. So is it going to be a big no-no for all the future applicants and for those who are already in the process of acquiring one?
The good question. So right now today, if I file H4 EAD for a person, that application is with USCIS. So if they receive that and it's filed before the rules implemented, then we have the ability to process for that benefit, right? So that person would still be able to be eligible for the H4 EAD.
Okay.
So yeah.
Right. Okay, and just what is your take on this whole H4 EAD removal thing, Lucas? Do you think it's a beneficial idea? I mean, do you think that it really is? Has a significant impact on the entire economy, or do you see it differently?
I think it has a significant impact on our economy. I mean, we're asking the members of a certain immigration class to be recused from working, and in America, what most people don't realize, our immigration system is really focused a lot on family unity, the family unit.
Right.
A lot of it's family-based immigration, but even for the employment side, we want families to be unified. We want families to come and grow in the United States together. We don't want to just take a worker to be here and then go back home. We want to have commitment and
hello.
Hello.
Right. Sorry to interrupt you, Lucas. I think we have a caller. Fine. Yeah. Hi. Hi, may I know who's calling?
Hello.
Hi, this is Justin.
Yeah. Hi, Justin. So there's another caller. May I know your name, please?
Justin Ose.
Okay. So yeah, I think we'll speak with Justin first then. Yeah. Hi, Justin. Please go ahead and ask your question.
Okay. So I am in H1B. H1B and my 140 is approved now, and the priority date is July 2017. The question here is, my son is in college now, third year, and dependent, he's holding a H4 visa.
Correct.
So whether we need to go for F1 visa or he can continue his studies in H4 visa. So he'll be turning 21 in March 2020.
So he'll need to work with the DSO and appropriately file for a change of his status. I would work with the DSO to see what the appropriate time would be, but I would recommend starting that process sooner than later. While he's changing his status, once the application's been submitted, he'll be maintaining his status, so he'll still be able to go to school and continue his studies. But each school and DSO might have a different procedure that they follow. Just that's unique to that school, that they might have their own rules and regulations, but I would reach out to them. It shouldn't be an issue, but make sure he keeps his timeline up to date to make sure he doesn't wait till the last minute to start the process.
So we mean that he has to start the process for a F1 conversion?
He'll need to speak to his DSO at the International Student Office. What school does he attend?
NJ80, New Jersey.
So there should be an international office at that school, and they should be able to help assist him with what their procedures on what they do. Since he's turning, so he's got about a year left before he needs to make sure he's changing status. Maybe this fall he needs to start the process, but he needs to work with them because they're going to have to issue. He's going to have the CVIS and everything else issued from them for him to do the change of status and move forward as an F1.
Yeah, so we approached the DSO office. What they recommend is get as you are mentioning, get the F1 visa as soon as possible. So whether we can convert from H4 to F1 staying in US itself, or we need to go to India?
No. You don't need to go for stamping or anything like that. He can convert from H4 to F1. The only limitations is if you're here on a visitor visa, B1, B2, you're not permitted to attend university until you've actually obtained the change of status to F1. So other non-immigrant statuses, you're able to continue the studies, such as H4. So he can continue H4 and continue studying because it's going to take 6, 7, 8 months to actually start to finish the process for his change of status, right? While his application's pending, he'll be maintaining his status. So if there's a gap, let's say he doesn't get an approval till May of 2020, that gap where from March to May, he's not going to be out of status because his application's still pending with USCIS. Does that make sense?
Yeah. So it takes eight months of processing time.
From what
minimum, right?
Off the top of my head, I think the current processing time is about 7 to 8 months right now.
That's right. That's great. So it's better to be here in US and apply for change of status.
Yeah, because you don't want him to miss any studies, right?
Yeah.
I would definitely recommend just staying here, changing status. Now, when he leaves, he's going to have to go for stamping. So you need to plan accordingly for that. So I know emergencies come up from time to time, but if he ever departs the United States after that change of status, he's going to have to go get stamped.
Okay. So if we are applying here to change of status, what is the form we need to fill up?
It's the I-539. And yeah, and you can work with the DSO, and you're going to have to get his CVIS and the I-20, okay?
I-29, I-20?
No, I-20.
20. Okay.
Yeah, the DSO gives you that.
Okay. Oh, okay. DSO will issue I-20. Okay. That's great. Thanks a lot.
You're most welcome. If you need help, let me know.
Sure. Thanks a lot for the information.
You're most welcome.
Thank you very much.
All right. Thank you so much for calling, Justin. All right. So sorry, Lucas, you got interrupted. We were talking about the H4 EAD removal, and you were saying that, yeah, it does indeed, have a significant impact on the economy. So please go ahead.
So, kind of continuing my thought process on this,
Okay.
we have both quite a number of high skilled workers.
Mm-hmm.
Average families affected by this, both husband and wife have master's degree.
Okay.
They're both contributing members to that industry. Now, let's say they're not, but it's still in America. We have equal rights for men and women. We have the opportunity for both parents to help provide for the family unit.
Right.
And like I said, the traditional, when the law was created for H1Bs, the H1B wasn't intended to be a long-term visa, non-immigrant visa. It was a dual intent visa. It was an ability for highly skilled worker to come work in the United States and have the option to get a green card. Now, due to the number of people that hold the H1B visa and the backlog with certain countries and certain categories, it's created an issue where, we don't want someone being idle for 10 or 20 or 30 years, not being able to contribute to the economy. So that's why this was created. And I think you have to look at the family, again, going back to family unit. I think there's a strong case to be had there to where we could challenge that in court to say, look, this is a resource that shouldn't be taken away.
Mm-hmm. Right. Okay. Yeah, Lucas, before we talk further, we have another caller. We'll take the call. Hello.
Lucas, this is Justin again. Sorry, I missed another clarification.
Go ahead.
Can I go ahead with the question?
Yes, please.
Thank you. So now, if you're converting to F1, I am in green card processing, right? If I get the green card, in case if I get the green card by next year, by March 2020, before March 2020, how can is it possible for me to apply green card for my son as well?
Correct. So, what's your priority date?
July 2017.
Under what category? Are you EB1, EB2, EB3?
I'm in EB2 now.
You're not going to have a visa that's available for, it's going to be many, many years unless they change the law, because right now I think we're 2009.
Yeah, that's true. Okay.
Yeah, unfortunately, if your visa were current, or if you were like, let's say you're EB1C, you were an executive or a manager here, and you were to get your GC in the next year or so, that depending on how old your son was when you started the process, he would have to remain unmarried, and then you could sponsor him through a family-based petition. There's other options, other avenues to go down.
So to use the family-based option, you should be below 21, right?
No, there's different categories. So depending on whether or not you're a green card holder, if you have an adult child, which is over 21, and you have a green card holder and there's no option for them to be a derivative, then if they're unmarried, you can still sponsor them depending on the country and everything else, you can see what the visa availability for the priority date would be.
Okay, that's good. Okay, yeah, that's all. Thank you. Thanks a lot.
You're most welcome.
Thank you.
Okay, thank you. Yeah. So, Lucas, yeah, you were just mentioning about the backlog and that 2009 EB2, EB3 petitions are being processed currently. And so my question here is, do you know of any plans, that are going to be made to expedite this process and, to catch up with the backlog? And also there's been a bill introduced recently in the Senate and the House to remove the pre-country limit for the employment-based green cards. So what are the chances that this bill gets passed, and how positive are you about this? And is it, yeah,
I think that ship has sailed. Last year it was Yoder amendment. It was a congressman.
Okay.
And he put together the appropriations bill, which is the spending and the budget for, which includes DHS, Department of Homeland Security. And part of what was presented in HR 392 was to remove country conditions and make it more of a even open category that doesn't designate certain countries. It would be just all first come, first serve, regardless of where you come from.
Right.
But we all know that the government went to shut down, and there were other things going on, and there's other new bills that have been introduced and funding that's taken place. So
right.
I don't really see anything happening for the next foreseeable future. Hopefully within we can continue this wave of change, and within the next 2 years to 3 years, hopefully something can be done in Washington, and we can get some of these much needed changes implemented.
Okay. So not in the near future then.
Correct.
Okay. So in case, if this country limit is removed, so fingers crossed, how quickly do you anticipate that these EB2 backlogs are likely to be cleared?
It'll move significantly. Any change that's going to take place isn't going to be like a rapid change. It could. They could. They have in the past introduced certain parts of the amendments to the law and things like this that have created a good large waivers or exceptions for certain groups.
Okay.
The last major one was what we refer to as under Section 245I. So there, for anyone who had a petition filed on their behalf before April 30th, 2001, if they entered the country illegally, then they could get a waiver and pay a fine and stay here and finish the process. So the government's done things like this in the past to help, fix certain problems that are there, right?
Right.
So it's hopefully they can do something on this backlog, because I don't want to go on too much about it, but for someone, we don't want someone staying in H1B for 20 years because obviously that's a lot of pressure to stay working for one petitioner. Or what kind of stress and pressure do you have every so often getting extensions, filing amendments? It's
right.
Tremendous amount of stress and pressure.
True. Yeah. So hopefully then some kind of steps would be taken to expedite this process. Then if the country limit is not going to be removed anytime soon, then I really hope that we have some other step in process to help clear these backlogs.
Correct. And you have to remember the backlogs, it's all prioritized. So there's certain visa categories like immediate relatives that get to move to the front of the line. So it's just, if you think about this, if I came from India in 2000, or let's say 2005.
Okay.
I got my GC, and so now I've had my GC for 5 years, and I'm becoming a citizen. Well, I might want petition for my mom and dad to come over here with GC. So those two GCs just don't magically appear out of thin air. They're allocated in part of the quota. So the filing for my parents just pushed back the EB2 and all the other categories just a little bit. Does that make sense? So that a lot of that, everything's balanced out, but we do have immediate relatives that have the highest priority. And that's something that has a large effect on this as well.
Okay. All right. Yeah. So, Lucas, one of our main agendas for today's interview is the H1B cap subject petitions. I mean, the procedural changes that have come up recently. So, would you like to explain those changes to us? I think I've read about a change for both H1B cap subject petition and H1B master's cap as well. So would you like to elaborate? Yeah.
Yes. So it was kind of a surprise here recently. There was not much notice. USCIS submitted a rule changing process similar to what we just discussed for H4 EAD. The process, the comment period was discussing about two things: switching the order of how the cap cases are selected. So we know that there's first the master's cap and then the regular cap.
Correct.
And so every year we would have our master's qualified U.S. master's candidates would be selected first, and then afterwards everyone who wasn't selected would go in with the regular.
The regular, yeah.
Correct. So now they're going to do the opposite. So since they say it's going to help increase the number of U.S. Masters picks, so we're going to put everyone in one group first and select all the cap cases, and then after that we'll just reserve everyone who's Masters and select the remaining 20,000 for the Masters cap.
Right.
So they say it's supposed to increase the probability of being selected in the cap if you have a U.S. Masters. I don't know, 10% or so. So hopefully it helps out. The second part would be for all the petitioners to file electronically and register. And no one has really seen the system or know exactly how it would work. But from what I understand, the employer would register with their tax ID number, and that would probably be their identifier. And they would probably place the information of what would be with the LCA in certain basic petition information requirements that we normally send on the forms. And I would imagine it'd be some kind of electronic submission where we just have what we call like a bare skeleton case. And then once those people are selected, who's in the cap, then they would have the opportunities to submit all the supporting documentation and things like that.
Okay. So the first one that you just mentioned, it kind of looks like, they're trying to give more opportunities to people who have done their masters and from U.S. universities. So giving more preference to them. And the second kind of looks like a cost-effective measure to handle this entire H1B lottery system. Am I correct?
Correct. And it's the first part. I will say this: whenever they've also last year changed. There's a decision in the case which limits how many petitions can be filed on behalf of the same beneficiary. So under the current law, it's always been this way. For the cap, one petitioner cannot file multiple petitions for the same person. So what some people have done is they say, well, I know company A, company B, company C, and they'll get 3 petitions filed to see if they get picked. And they use the same project documents from the same job. That's permissible. I still think it's permissible, but there was a case decided last year which says, well, if we are now determining that that's a duplicate filing, if we determine that even if it's from two different petitioners, if you still have the same layers involved, if you still have the same contracts, if it's still the same clients, that's considered duplicate petition. So that was done to help discourage the multiple filings. So I think some of these changes, along with that, you'll see a higher acceptance rate among U.S. Masters students.
Okay. So, I mean, in which fiscal year are these changes likely to come into effect, Lucas?
Fiscal year 2020 is when we're going to have, which is this year's cap, we're going to have the reverse of the order of the selection of the H1B petitions. And I would probably guess fiscal year 2021 for the electronically selected part of this. But I always tell people, if USCIS keeps denying petitions and removing people from the country, who's going to create the system to electronically select everyone?
Right. Yeah. So, I mean, clearly, I mean, so this new strategy is beneficial for the US, I mean, master cap applicants. But is this by any chance going to slim down chances for the regular cap applicants, Lucas?
I think overall, and this is not just this administration, but I would say overall 3-4 years now, you've seen a sharp decline in the number of people who are filing from abroad for a consular case, and pretty much it's almost impossible to, unless you're working with a large company, to get selected and an approved case if you're actually just living in India. The petitioners are required now to, you can't, the in-house development of certain projects is a very difficult task right now to get an approval for. Then, you typically would need, especially if you're working for a consultancy firm, you would need the MSA, PO, and all this, and you typically can't get that or have any offer of employment if you don't have a background check, and you can't get background check if you don't have social. You can't get social unless you have a H1B visa approved or some other form of status, right?
Okay.
So it's almost like we're getting close to pretty much what I see when I file cap cases is people who are F1 students here. If there's H4s who might have H4 EAD and they want to do a change of status, similar to what we spoke about earlier, or someone changing from some other status that might have some type of work authorization. And that's typically, for the most part, what we file cases for. It's almost so to answer your question, it's still a high demand for the visa, but I think the demand, most of the people applying for the visa are U.S. master's degree.
Right. Okay, got that. So, I mean, last year's statistics, they suggest that there have been a lot of rejections based on the specialty occupation. So, around that, we have about 3 to 4 questions that a listener had sent us. So, I'd like to read them to you. So, would you answer them?
Sure.
Okay, great. So, the first one is documents that are needed. What are the documents that are needed to support employer and employee relationship specialty occupation for F1 with masters in MIS?
Okay, so basically, one of the core concepts is when USCIS reviews a job for a specialty occupation, they don't review the job title itself, but the job duties. Having said that, the most important way you can document job duties is going to be in client letter, statement of work, PO, something to show we need this, and this done for this position. We need the position from date 1 to day 2, right? These are the things that are being looked at. There has been a lot of responses from USCIS saying we don't, this seems like a generic statement of job duty. So the more detailed we can get, and what I always recommend also, there's a recent policy memorandum that was issued this last year. And I always request people to, hey, if you have a slide deck, if you have project docs, if you have sprint plan, if you have anything that can help show not just what your job duties are, but the actual work that's being done, or a larger scope of what the project is, that's also wonderful supporting evidence.
So the more detail, the better.
Correct. So whenever you're talking about specialty occupation and things like this, so we have a certain number of flavors that come up. We have specialty occupation, right to control, this third-party offsite employment. It's all encompassing the availability of specialty occupation work and things like this. That's what they're looking for the most part, because most all employers work with attorneys. They know what SOC codes qualify as specialty occupation, which ones are red flags, so to speak. So that's typically when they issue these RFEs, they're wanting the strong documentation. Want to see letters from all the layers. They want to see contracts between all layers, etc.
Okay. So apart from this, anything else that can help them, avoid rejections based on specialty occupation? Anything else that you want to add to that?
Yeah. So a lot of people request these expert opinion letters.
Okay.
Those have also been scrutinized highly here in the past year or two. If you do go the path of getting a experience letter, it's best to work with someone who will be able to come and see your work, the company, communicate directly. USCIS has been determining that it's not a valid form of evidence if the evaluator hasn't seen the work, gotten more information about the petitioner, et cetera, right? So they're kind of saying, well, you can use an expert opinion letter, but that's not really an expert opinion if they don't really know what your business is.
Okay.
So that's been an issue that's been here recent.
Okay, Lucas. So, moving on to the next question then. How to handle if a client letter has project end date of 1 year with possible extensions at the time of applying H1B, considering employee is working at the client location from past 18 months? That's another question.
I always tell people that, and this past year has been very evident with this, don't be greedy when it comes to requesting validity periods like this. If you can get your H1 approved and you can get cap exempt, that's the main goal of this. Don't worry about, I need H1B to be a fully 3 years. There's current litigation that's pending with, IT filed this litigation, and it's moved past the first stage of summary judgment, or a motion to dismiss by the USCIS, and now we have, the IT serve has motion for summary judgment, and they're collecting, I think, some additional evidence, and I think it's going to win, and that will help reduce this whole issue of looking at a client letter saying the exact date is February 3rd of 2019, so therefore we need to approve the case, but that it's going to be approved to expire on February 3rd, 2019, which has already happened. The date's already come. So that issue hopefully will be corrected here soon. But I would just always advise all the students who are going through this, the CAP case, just focus on getting your H1 approved so you're CAP exempt. Because once you're CAP exempt, it gives you more flexibility to do other things. You can port over to another company. You can always market and get a different position. There's so many things to do.
Right. Okay. All right. So I hope that answers their questions and question. And then the third question is, what documents do we need from vendor and client, and how the content should be in letters to get H1B approved without any denials?
Well, I will say this. So don't worry so much about templates or anything else. You want to make sure whenever you have your client letters, vendor letters, that they are stating, the project scope, the the job duties, job description, job duration. Usually a really good client letter is at least 2 pages.
Okay.
You also want to see, if possible, to share the MSA and PO between the two parties. And that becomes difficult. A lot of people who are filing for CAP cases, if you're OPTing on project, you might have 3 layers. So you might ultimately be working with WePro or TCS or someone like that. And sometimes it's very hard to get any information from those vendors. So it's just a matter of just trying to get as much information as possible. And like I said, the other supporting documentation, slide decks, project docs, sprint plans, all that help out tremendously.
Okay, great. All right. So there's one more question, Lucas. I'm sorry we're past our show time,
No, it's
but
fine.
I'll try. Okay, thank you very much. So the next question is: students on OPT do they need to prepare any additional documentation to just practical training and work? If yes, how their documents should be and how should the content be?
Very good question. Very good question. So this past year, I wanted to bring this point up earlier.
Okay.
I think I've discussed on the show earlier that it's up to each student to maintain their status and show that what their training plan is, to make sure that they're showing the link of their degree to what the job function is. We've seen a lot of RFEs requesting maintaining status in F1 or CPT or whatever it might be. So a lot of people, after their post-completion, go for STEM OPT. Well, when you submit the 983, you need to have your training plan. You need to show what the work is, get all this information before RFEs issued. Be prepared, be proactive to show, like, this is my communication with my employer. This is what we've been doing. Here's my email communication, or here's my status updates. Here's my reporting. Be prepared. Try and get as much of that evidence ahead of time. And then also make sure you work with your petitioner to have an established multi-page, not a one-page sheet that you send with the 983, but you have a booklet similar to how people have, their employment handbook. Have something significant that shows what the training is, what are you doing, what technologies are you using. Have something substantial, and officers can tell if you wait till you get RFE before you start making evidence. So do the right thing and just kind of have this as you move along, and it's documented. That's the correct way of doing this.
Okay. All right. So those were the questions that we got through messages. And finally, Lucas, regarding the Farmington students issue. So what is the current situation of the students? And out of 130 students, how many of them have received bonds so far? How many? Just a generic update on that, if you could give us.
I think from what I've seen and heard from other attorneys, there's still maybe 20 or 30 people that are pending the process. I had a hearing yesterday in Pennsylvania, and the 2 gentlemen I represent were granted voluntary departure. Okay. So it's just a matter of when the court dockets are open. There's been another gentleman that's I think works with the Somi Ready firm. I forgot his first name, but he's he went out and the gentleman that works for Santosh. He was successful the other day in getting a couple of guys out with voluntary departure as well. So it's been a coast to coast team effort. There's a lot of other people that have been involved. I'm trying to look and see if I have any numbers for right now.
Right. So
it looks like it looks like five
ahead,
more people in LA were given voluntary departure today.
Right.
So it looks like we should be down to around 25 or 30 people still pending, I think, if my estimates are right.
Okay. So I have also seen those messages where saying that 5 people had gotten this voluntary departure. So definitely there is some significant progress that has been made here. So with the way the proceedings are going so far, do we see some hope for the students who are still in detention and who are yet to appear in courts?
Yes, I think it's a very positive show here, or evidence from everything that's going on across all jurisdictions. That ICE appears to be agreeing to the voluntary departure, and that in the voluntary departure, for those who don't know, order of removal is very bad. That gives you, it's a 10-year bar. So the voluntary departure is saying, okay, you're going to voluntarily depart the United States, and it's not going to have an impact on your immigration record. When I say that, it's not an order of removal. Now, if there's any unlawful presence that you have while you were here before removal, that's a whole nother issue. But, for this, it helps the person regroup, and if they want to come back, it's easier to come back.
Oh, is that the case? I mean, so in case of in the future, for people who have received this voluntary departure, if they'd like to apply for a H1B visa, then is it going to be a rocky road for them, or is it going to be for those who received BD?
It just depends if they determine if, whatever it might be, if they have any unlawful status or anything like that. If all that's not an issue, there shouldn't be a problem for them to come back. We also handle cases here. Let's say someone does have an order of removal.
Okay.
And let's say that they have a wife or something that wants to sponsor them, right? Well,
right.
You can't just go file with USCIS. What we have to do is do a motion to reopen the case. We have to reopen the court case. Then we have to move either to close the proceedings or something else to happen, right? So it takes for someone wanting to come back here, potentially in some other visa status or whatever, it makes it much easier. There's less administrative work, right?
Right. Okay. All right. So, yeah, Lucas, anything else that you want to add that I may have missed out asking you? Any important update? Or are we good?
I think we touched on all the major changes coming, and we had a lot of great participants today with a lot of great questions. So if no one else has any questions, I think we pretty much covered all the topics we wanted to discuss.
Okay. Awesome, Lucas. Yeah. So lastly, I have one informal question. I hope you wouldn't mind answering that.
Sure.
So what are your weekend plans, Lucas?
Working. We're preparing for the CAP. We already have quite a few cases we're onboarding, and we're trying to stay up to speed with everyone. So.
Oh, awesome. I mean, we really appreciate your dedication, Lucas, and I mean, for all your efforts so far. You're doing a commendable job in helping out the students.
I appreciate that. I do want to add one last comment, if I may.
Sure.
I want to just mention this for everyone who's on H1B or F1. I want you to take a moment and think about your employers. A lot of these employers with these students have gone above and beyond the duty of taking care of their employees. And I've helped a couple of people specifically that some very large companies have been very involved, helping and offering to pay for tickets home, being there the support for these students for these, while they're not here, they don't have family, they might just have friends. And it's very commendable. I think that the best way people can show gratitude for that, remember whenever you select someone that you're going to work with, it's not just how much someone pays you. It's not just what you think you're owed. A lot of these employers really care. And a lot of these employers are there for you when you might need them. So going full-time all the time or cutting layers or going to somewhere else is a short-term remedy. But I can guarantee you this, Cognizant's not going to go out of their way to help one of these students. They'll be just terminated and they'll have to figure it out on their own. So I do want to say that there's quite a few of these employers that have been actively involved trying to help make sure that their employees are out of this problem and back home safely. And I think that should be commended.
Okay, sure. Thanks so much, Lucas. And so if that was for the H1B holders. So, Lucas, for the students that are, still, studying in universities that offer day one CPT. So, do you foresee any kind of, raids that might likely to take place in the future, so that, you can just tell all the listeners upfront, and
Sure.
so they can be more vigilant?
I would tell you this. There's another school that we've somewhat identified as another potential USCIS scam.
Okay.
The school is MFTI, and it's based out of Tampa, Florida. You can look up the address. The actual name of the school is it's MFTI University.
Tampa, Florida. Okay.
Yes, Mid-Florida Technological Institute, and they're advertising day one CPT, CVIS approved, DHS certified, all these things. But if you look at the address, it's in a warehousing district, and it's within walking distance from a USCIS field office.
Okay.
The URL has been active for only 2 years. It was created around the same time by the same people from Farmington. So there's other schools out there. Be careful. Cover your bases. Make sure if you're approached by one of these institutions, or if they are aggressively recruiting, which they do.
Okay, so
make sure
they haven't raided the university yet, but it is in the radar. Is that what you're saying?
Yes. Well, it's not a raid. It's a fake university.
Okay.
So it's just like Farmington, and you can go. I'll give everyone the URL. It's mfti.edu. Mary Father Tango Igloo.edu.
Got that.
And that way everyone can share it. I mean, they're active on Facebook, and they're out there, and we need to allow everyone to know this so we can shine the light on this to avoid this.
Correct.
And there's other schools out there that are legitimate schools that do day one CPT. I think there's one in Kentucky. I forgot the name of it. But I said, just as long as any status you're in, make sure you're maintaining your status. Make sure you're doing what you're supposed to do. If you need to report and be at school on day one, make sure you're reporting and attending courses. And it's, if you maintain your status and document everything correctly, there shouldn't be an issue in the future.
Okay, sure. So, last question, sorry. What is your suggestion to these, students, who are studying in this fake university, MFTI? What is your suggestion to them in case they have not been approached by ICE yet?
Well, ICE isn't going to approach them because their CVIS is still valid. So I would recommend changing universities or immediately changing or doing something different, because it's a very, I would say it's a 99.9% likelihood this is a Department of Homeland Security university.
Wow. Okay.
Okay, so maybe we can even share that on the Facebook page to be aware of this school or something like this through the radio.
Sure, we do that, Lucas, definitely.
Sure, and we're trying to get more information for local news outlets, because I'm actually kind of appalled that no major news sources picked up on this and about how these students are entrapped. Most of these students are unknowingly participating in this, and they're paying money for tuition and everything else, and it seems it's such a crime to be affected. Yeah. And there's most of these guys are stuck in jail for 1 month. And it's horrible. We should have all the media focused on this, asking a question: why is USCIS using resources to create a fake school to arrest 9 people? At the end of the day, only 9 or 10 people were arrested for immigration fraud. But we've affected the lives of 600 people.
That's right.
Why is that important?
Yeah, but there isn't much buzz about this through the media or anything, right, Lucas? Unfortunately,
we've tried through Washington. There's the president of Telangana Association. He's been working with a few media outlets, and I spoke to him at length about this, and I said, I can't believe that there's just no traction. we've spoken with a few other media sources from India, and it seems like it's a bigger story in India than it is here in the States, and we don't want to discourage. We don't want to discourage the brightest minds in the world from coming to the United States to study. I mean, this is what this is doing. This is going to end up being a deterrent, and we don't want that.
Correct. Yeah. I hope that happens to Lucas. I mean, I really hope so. Some momentum takes place, and media or authorities from India take this up even more seriously and work towards it. I'm sure there are so many associations that are already trying to get this, get the students out as fast as they can. But certainly, I think some more help would really help, expedite this process and get the students out.
Correct. And again, this isn't the first, this is the second fake university. So
That's
it's not
right.
the first one this happened in New Jersey, I think 2 years ago. So it seems like the government's trying to continue this to maybe force people to leave, I don't know. I still think that there's some kind of a scheme with a very anti-immigrant administration here to try and say, hey, we're going to catch the people like this, revoke their SEVAs, arrest them and make them afraid and make them leave, and maybe that's a deterrent for more people coming here. And I think that's the true intention.
Right. Yeah. You've been really forthcoming, and you've always voiced out your opinion on this so boldly, Lucas. Thank you so much for all that, and also for patiently answering all our questions and all your valuable suggestions.
Thank you. You're most welcome, and thank you for having me on the show. I love participating and speaking with everyone from the community.
Same here. It was a pleasure talking to you, Lucas. Thank you so much for being with us. Sorry.
Thank you so much.
All right, then I think we're good to end the show, Lucas.
All right. Have a good weekend.
You too. Thank you. Bye-bye.
Bye.
Okay, so my dear listeners, మరి విన్నారు కదా, చాలా అప్డేట్స్ ఇచ్చారు ఇవాళ. H4 EAD రిలేటెడ్, H1B వీసా క్యాప్ రిలేటెడ్ క్వశ్చన్స్ కానీ చాలా అప్డేట్స్ మనకి ఇవాళ లూకస్ గారు ఇచ్చారు. అండ్ ఆల్సో ఆయన ఎండింగ్ లో చెప్పారు కదా, మరి MFTI.edu అనే ఒక సైట్ ఓపెన్ చేస్తే మోస్ట్లీ 99.9% ఇది ఒక ఫేక్ యూనివర్సిటీ అయ్యే ఛాన్స్ ఉందట. మరి ఇందులో చదువుతున్న స్టూడెంట్స్ ఎవరైనా ఉన్నట్లయితే, మరి మన షో వింటున్నట్లయితే చాలా విజిలెంట్ గా ఉండండి. మరి ఐస్ వాళ్ళు అప్రోచ్ అవ్వక ముందే కూడా ఆయన ఏం సజెస్ట్ చేస్తున్నారంటే, మీరు ఎటువంటి ట్రాన్స్ఫర్స్ అన్న తీసుకొని ఎడ్యుకేషన్ కి సంబంధించినవి మెజర్స్ తీసుకోవాలని చెప్తున్నారు అనమాట. సో మరి బీ వేర్ ఆఫ్ దిస్ అనమాట. MFTI టాంపా ఫ్లోరిడాలోని యూనివర్సిటీ అట. వెబ్సైట్ URL కూడా ఇచ్చారు, MFTI.edu. సో మరి అందరికి స్టూడెంట్స్ అందరికి ఒకవేళ ఇందులో చదువుతున్నట్లయితే బీ ఎక్స్ట్రా విజిలెంట్ అండి. అండ్ ఐ హోప్ మరి మీకు ఇటువంటి ఒక బ్యాడ్ ఎక్స్పీరియన్స్ అవ్వకుండానే మీరు మంచి మెజర్స్ తీసుకుంటారని అనుకుంటున్నాను. ఆల్ రైట్. సో మరి H1B లాటరీ సిస్టమ్ కి రాబోయే చేంజెస్, అట్లానే H4 EAD రిమూవల్ అప్డేట్స్ అయితే ఏమైతే ఉన్నాయో, ప్లస్ ఇవాళ డిస్కస్ చేసినటువంటి అదర్ ఇమిగ్రేటెడ్ రిలేటెడ్ ఇన్ఫర్మేషన్ అంతా కూడా మరి మీకు ఉపయోగపడిందని అనుకుంటున్నాను. ఇన్ కేస్ మీరు ఇవాళ షో కనుక మిస్ అయినట్లయితే, ఏదైనా ఒక స్పెసిఫిక్ ఇన్ఫర్మేషన్ మీరు మళ్ళీ ఒకసారి షో విని తెలుసుకోవాలి అని అనుకుంటే కనుక తప్పకుండా మీరు చేయొచ్చు అనమాట ఆ పని. యూట్యూబ్ లో తెలుగు NRI రేడియో ఛానల్ ని మీరు కనుక సబ్స్క్రైబ్ చేసుకున్నట్లయితే ఇన్ లెస్ దాన్ ఎ డే మీకు ఇవాల్టి షో ఆడియో, కంప్లీట్ ఆడియో అనేది అవైలబుల్ ఉంటుందండి. మీరు అక్కడ తప్పకుండా వినొచ్చు అనమాట. సో అది మరి ఇవాల్టి మన స్పెషల్ ఇంటర్వ్యూ. ఐ హోప్ చాలా చాలా ఇన్ఫర్మేషన్ ఇచ్చారు ఆయన మనకి సంబంధించినది. సో ఇన్ కేస్ ఏదైనా ఒకటి అర్థం కాకపోయినా కూడా మీరు డెఫినెట్ గా మళ్ళీ వెళ్ళి ఆ ఆడియోని యాక్సెస్ చేసి వినొచ్చు అనమాట. అదనమాట. సో దట్స్ ఆల్ ఫర్ టుడే అండి. ఐ హ్యాడ్ అ గ్రేట్ షో. కాల్ చేసిన వాళ్ళందరికీ కూడా థ్యాంక్ యూ సో మచ్. మరి మండే మన యూజువల్ సరదా కబుర్లతో మరి మిమ్మల్ని కడుపుబ్బ నవ్వించేటటువంటి క్రేజీ సెగ్మెంట్స్ తోటి మరి మీ ముందు ఉంటాను మన రెగ్యులర్ హ్యాపీ అవర్ షోలో. మరి విష్ యూ ఆల్ హ్యాపీ అండ్ రిలాక్స్డ్ వీకెండ్ అండి. సో సీ యూ ఆల్ ఆన్ మండే. అంతవరకు మరి స్టే హ్యాపీ, స్టే హెల్దీ. వినిపించు ప్రవాసాంధ్రుల గుండె చప్పుడు తెలుగు NRI రేడియో. RJ Nammy is now signing off. Tata.